For those in the audience, you're the studio audience, and Gerard, the two Gerards, we're filming them in conversation, so to speak. And so, Richard, you have how much? Probably like 35 minutes left on the film? Okay, good. And now, do you need a clear shot? Does Arthur need to move to the side? Yeah, I know, but still, Arthur, maybe just to the end of that row where you are. That's good. Thanks. Good. Okay. Okay. Good afternoon. My name is Margie Russell. I'm the Executive Director of NIARM, the New York Association of Realty Managers. And it gives me great pleasure to introduce to you Gerard McCabe and Gerard Keogh, and they are going to introduce their firms and discuss with you the concept of who pays for late construction, the owner or the contractor. Thank you.
Thank you, Marge. And I want to thank NIARM. We looked at their agenda today, and it was quite impressive, and there was some crowd out there, so great job, Margie, as always. Thank you for having us. We're excited to be here. We're partners, Jerry and I. Just to make it simple, I'm Gerard McCabe. He's Gerard Keogh, but he goes by Jerry, so it's real simple to differentiate us. We are partners in a firm called McCabe Law Global. We have a thriving practice globally, as in a name, and we do have a focus on construction. So today's topic is one that's quite prevalent, one that anyone that is involved in real estate, particularly if you're owning or managing it, knows a little bit about, and we're going to try to fill in those gaps and take any questions to try to give you an idea of what you need to do when you are in the midst of a construction project and there is a delay. So to give you an overview, the causes for delays in projects obviously are numerous, and I'll go through the bullet points in the handout. But they fall into two categories. Normally, it's someone's performance, or it's about an unforeseen condition that occurs on the site. So you have design errors, you have unforeseen ground conditions, you have environmental conditions, you have poor trade scheduling by a general contractor or a sub for that matter. You have performance issues with the contractors themselves, who are either negligent or what have you. You have neglect by the owner or the construction manager or someone else that fits into the food chain of the world of construction. And you also have governmental issues like stop work orders and OSHA investigations that play into this issue also. So who sustains these damages as a result of a delay? Obviously, everyone within the food chain of a construction project is exposed to some kind of liability, and it goes from the owners, the designers, architects, construction managers, all of the subcontractors, right down to the vendors and the suppliers. They all are exposed when there's a delay, depending on who did what, when, where, why, and how. So we're going to focus on how the delay damages are apportioned, because that's really a critical issue. How are they apportioned between all the parties that I've just mentioned? And that's an issue that's plagued construction projects and developments since many, many years ago. So we broke this piece out into two aspects. Jerry's going to handle the historical background on this issue because it does go way back. And after he's done with that, I'm going to talk about the modern state of affairs. Jerry?
Thank you, Gerard. Thank you, Marge and NIARM, for allowing us this opportunity to discuss this issue, which basically affects your members. If you're a real estate owner, or you're people who represent real estate owners, you have to deal with this issue of a delayed budget. Is the budget coming in under time? Are there delays in the ground conditions? Are there, as Gerard mentioned, are there delays in the scheduling? Those delays, especially if you're doing construction financing, can be devastating. If you are representing the owner, you're going to want to make sure that those who are developing your land are bearing that cost in the form of the construction contract. Now, this issue, as Gerard mentioned, has been a source of tension between the landowner and those who improved the land going way back to 1780 BC in the Bronze Age. Now, the Bronze Age was a kind of unique period of time, very similar to the technical age that we're in now. It was a changer. It was a game changer. Ironically, modern-day Iraq was Mesopotamia back there. Mesopotamia was viewed as the first New York City-type economy. The Bronze Age changed everything. There was an affluence that was hitting modern-day Baghdad like there had been never seen in the globe before. And where in the Stone Age it was might make right, there were no lawyers, there was no courts, there was no way to apportion, as Gerard says, the damages. So once the Bronze Age came, the affluent classes in Mesopotamia started saying, we don't have to develop our land. We can pay people to do that. And then there were people who were saying, hey, you know what? I can make a good living by going on this land and developing this land for this rich landowner. And, you know, he'll be happy and I'll be happy. So you started having this sort of roots of capitalism, and capitalism as it was tied down to the land. Now, what happened was King Hammurabi, he made a decision that, you know what, I'm going to get overrun, and Mesopotamia is going to get overrun, and this affluent lifestyle we have is going to be overrun because we own this bronze. We know how to procure it, we know how to manufacture it, and we know how to distribute it. So in order to keep everybody at bay, we should have some laws. And I need my society because now I'm going to have very, very rich people, I'm going to have people in the middle, I'm going to have people who are left outside the income stream, and there's going to be inherent tensions on that. So we need laws on real estate, we need laws on construction, we need laws on family life, we need laws on, you know, social life, and that became the Hammurabi Code. Much of what lawyers learn in law school, and much of what they do when they speak to you, the people who are managing the real estate, derive from that Hammurabi Code. And a prime example of that would be Law Code 45. Law Code 45 was enacted by King Hammurabi, and the role of a lawyer back in the Hammurabi courts was that of an officer of the court, much like Gerard and I were deemed to be officers of the court. But the role was not that of an advocate. Their role was more when a party had a dispute between the landowner and the person who was going to develop that land. That dispute, those two parties, the landowner and the contractor, would come into court and they would plead their own case, but they'd have to plead it according to the instructions that the court lawyers, because the lawyers worked for the courts, these ancient lawyers worked for the courts, stated. And then the question came down to is, well, what happens when there's a delay that nobody saw? Or even if it was foreseeable, it was inopportune. And that delay damage, it was covered by Law 45, stating that if there was any damages that happened in the cultivation of this land, that was the result of damages that was unforeseen or foreseen, the party who's the tiller, the developer, the contractor, they're going to bear those costs. And that started a legal precedent that really pretty much covered from those from the Bronze Age all the way through the Greco-Roman times. And at that time, law developed a little bit, because as land developed and as during the Roman Empire and during Grecian times, the land became, the construction projects become more complex, and affluence became so disproportionate that lawyers went from the role of being advisors to being advocates. You would hire the lawyer to go in and argue the case, and then there was an issue with respect to what happens when that damage cause an unequitable loss, an unconscionable loss. During this period of time, Aristotle wrote the natural law, and that he wrote towards the end of his life because he was fearful of the Athenian courts. Remember, his professor, Socrates, was put to death by the Athenian courts, and the view was he was challenging the corruption that were in the courts then. What Aristotle wrote in Natural Law became much of what we learn in equity when you're in law school and when you're trying to get out of a delay clause in a contract, that there was a concept called unconscionability. If one party, the landowner, did really, really well and the contractor did really, really poor, that was deemed to be unconscionable, and you could apply to the Roman courts who really evolved from the Aristotle natural law to state, hey, I want to be relieved from this contract. I took too much of a loss. That was on there. Well, what then sort of developed was as that ancient Greco-Roman principle developed, they actually established in London towards the end of the medieval periods, the Court of Chancery. And the Court of Chancery, what that did was, if a landowner came in and they did really, really well, and this contractor did really, really poor, then that you could apply for a writ to say, hey, look, I lost too much money on this contract. This landowner did really, really well on this contract, and it's unconscionable. I want to get a relief from that. At this juncture, the law developed to the point where you could get relief from a no damage for delay clause. Now, what a no damage for delay clause is, what's called an exculpatory clause, is that if you had a contractor who was to improve the land, and that contractor suffered damages because of unforeseen conditions, a storm, a labor dispute, riots, they could apply to the Lord Chancellor's Court for a writ to be relieved from that clause. And that clause was really rooted, and that court was even rooted into Aristotle's natural law, where equity, the balance of equities, where no party will get hurt in a transaction. And that basically was the law of the land to the times during the American colonial policies. You could get relief from a bad contract by going to equity. And that theory developed as the country developed into the federal court system. And at this juncture, now that we're into how this law applies to the United States, and in particular in New York today, I think I'll turn it back to Gerard so that he can sort of deal with the issues as it developed through history.
Yeah, so now we're up to the modern day, 1965. There's a famous case called Williams v. Walker. It was written by a great judge by the name of Skelly Wright. And what he did was he formalized what Jerry just defined as what is unconscionability. He actually created a definition of it. And that definition is pretty simple. If one party gains too much from a contract provision and the other party was harmed, then the contract provision is stricken and unenforceable, and as such, the contractor can then sue for damages. Those damages that, as we see later in the next few decades, those damages are basically the result of a delay. And it certainly sounds fair to most people. So at that juncture, it didn't matter what the actual contract was. It didn't matter what was in the contract. If there was a clause in the contract that was unconscionable, you could sue, have it stricken, and then you could move to court for damages. And things changed quite dramatically in 1986 when the New York Court of Appeals came down in a case called Carina Cervetta Construction v. the City of New York. And that case pretty much turned the law upside down. And what it said was that, well, there will be 4 exceptions that we'll consider as unconscionable. And the exceptions were delays caused by a general contractor's bad faith or willful, malicious, or grossly negligent conduct, uncontemplated delays, delays so unreasonable they constitute an intentional abandonment, and delays resulting from a general contractor's breach of the fundamental obligation of the contract. The problem was these 4 exceptions, as the case law developed, they were never applied. There was never a fact pattern that the court found fell into one of these categories. So what it basically did was it reversed the Judge Skelly Wright's decision and William v. Walker, and all of a sudden, what was in that contract became, unpenetrable. You could not sue in equity for a delay claim if, in fact, there was a clause in the contract that basically precluded you from doing that. It didn't matter how unfair the contract was. If an owner and a contractor signed an agreement and there was a no damage for delay clause in that contract, then basically, regardless of how extended those damages were, the general contractor was forced to absorb all of the damages. So from a owner's standpoint, that's obviously a good thing, because the owner, his liability and his exposure was reduced tremendously if, in fact, he had a clause in his contract where no damage for delay was in it. Now, there's one issue that jumps out at me when I think about that concept. Most owners, if you just hear that, you say, hey, I'm in pretty good shape. The problem is a lot of owners, they use AIA contracts, which are form contracts that most people consider a good contract. Unfortunately, AIA contracts don't have no damage for delay clauses in them. They don't have a lot of different clauses in them that could protect the owner. So what the owner needs to understand is, number one, if you really want to take advantage of the law and protect yourself, then you need to do so before the project begins. You need to do so before you even consider what general contractor you're going to hire. You need to have their attorney come in and write a contract that's molded to the owner and to the project, not an AIA contract, but a contract that's very specific to the owner and its project. And in that contract, they would have a very specific no damage for delay clause. They would have perhaps maybe a time is of the essence clause in it, and other clauses that are very protective of the owner. So the second issue that jumps out at me is, if you're going to have that kind of a contract, what you need to do is really vet out the general contractor before the project begins, because what you're doing is you're putting a general contractor in a position where that general contractor might have to absorb damages that are so extreme that's going to put them out of business, and what's going to happen to your project? Your goal is to have a successful project, to finish the project so that you can take advantage of that building going up or whatever the project might be. So now your general contractor can't absorb the damages because you didn't do a good enough job vetting out the general contractor, perhaps demanding a performance bond or some other methods where you could actually test the bona fides of that general contractor to know that if there was such an issue, they could absorb that cost and it would not impact the project that you're most concerned about. So that's something that's very important from an owner's perspective. Make sure you spend time really vetting out the contractors so that if you're going to have these sort of restrictive clauses in the contract, you're going to be in a position where the project will not be impeded if damages that are extreme arise because of the myriad of reasons which we stated earlier this afternoon. So what happens is, after Karina, all of the exposure shifts to the general contractors. And that was promulgated in a case called Premier New York v. Travelers Property. In that particular case, Judge Freed ruled that the owners and the construction managers, they can be negligent in discharging their contractual duties, and the subcontractor must assume all of the damages that those other parties caused. And of course, the subcontractor is always the party that has to sign a contract that includes provisions that the owner forced the general contractor to sign. And the general contractor, in order to be covered, they're going to put it in the contract with the subcontractor. So the subcontractor is at the bottom of the totem pole, because the vendors and suppliers are a little bit different, it's a different relationship. So the subcontractors are the contractors that usually that have the most oppressive contract provisions. And in this case, Premier New York versus Travelers, the court basically ruled it didn't matter who caused the damages, the general contractor, so the construction manager, the owner, and it didn't matter if the subcontractor's hands were clean, were pristine. It didn't matter. The subcontractor had to absorb the losses. So it really did drive home the fact that the owner could really protect themselves if they draft the proper contract and spend the time before the project begins on really forcing their attorneys to focus on these issues and to make sure there's an ironclad contract that protects them to the fullest extent of the law. So what does it come down to? It comes down to too many, owners and other parties in the construction world. They don't think too far ahead, and they find themselves in the courtroom before they know it, and they're absorbing significant legal fees and extended periods of time before their problems are addressed. So what this really calls out for is to settle these issues in a boardroom, not a courtroom. Settle them in, way before your project begins. Sit down and do all of the vetting out that you need to do in order to enter into a project in the strongest position that the law allows. Sometimes that creates issues with maybe getting a good contractor. Maybe a really good general contractor is going to say, okay, I'll absorb this exposure to damages, but I'm going to put a premium on my contract price because I want to be able to, satisfy those damages if I need to, and I'm going to get my piece of it from the owner. And the owner quite often will say, sorry, I'll go to somebody else. And any good contractor will walk away from that kind of a contract because it really does expose them to quite a bit of liability. So sometimes as an owner, you got to be careful that you don't push away all the good contractors and you wind up with a contractor that perhaps not, especially if they're not vetted out properly, that perhaps might have a problem finishing a job. And that's one thing you don't want. You want your project to be on time, and you want it to be done properly, and you need good contractors to make that happen. So there's a real balance in of how you take advantage of this law without hurting yourself from an owner's perspective. And there's one other very critical point that we need to raise here. And up until this point, it pretty much sounds like the owner is going to have his way if the contract's drafted properly. But there's been some recent case law that's suggesting that there's a crack in the Carina case, that there might be some new case law coming down that might kind of go back to some of the language that Judge Skelly Wright was talking about, where it didn't matter what was in the contract. If it's overtly unfair, there might be some equitable relief that a party can seek if they feel as if they found themselves in an unconscionable situation. So from an owner's perspective, right now, you're still in a pretty good position, but what I would caution everyone is to really speak to their legal counsel and tell their legal counsel that right now it seems to be a bit of a shift, a little bit of change in the winds, and that their counsel really needs to kind of keep their eye on the ball to see how this case law develops as we move forward, so that you can change with the times. If the case law changes, you have to respond to it and adapt to it, again, to most protect the owner, your client, in a way that diminishes their exposure to liability when you're building a project. You have anything to add, Jerry?
I do. If I'm going up and get a contract, and I represent a subcontractor, and I see that the owner's being represented by a lawyer like Jared McCabe, I know that what's called exculpatory clause, the no damage for delay clause, is going to be really airtight. So if I say, okay, I'm going to Z that out, Mr. McCabe has got his clients well schooled to say any Z's in a contract, any Z outs, cross outs, reject it right away, saying this is a non-negotiable term that's on there. What I'll do is I'll use what's called a term of obviation or amelioration. Well, I'll go through the contract, and I could take maybe 3 paragraphs or 4 paragraphs of Mr. McCabe's exculpatory clause, and I can change it by putting conditions in, which I've done successfully on behalf of subcontractors. I'll put in, well, this will be subject to any and all foreseeable delays, meaning that I'm excising unforeseeable delays. Or I'll put at the end of the contract, notwithstanding the foregoing, nothing contained herein will waive any of the rights that my clients have to sue for damages that go above and beyond the scope of the services that were provided in the general conditions. That's a term of obviation. So I guess what would you advise when you get a lawyer who's now taking that very carefully drafted exculpatory clause and knowing that I can't get redress from the courts, I'm going to take Gerard's admonition. I'm going to do it right there in the boardroom. What's your solution to that if you're representing the landlords?
Oh, if I'm the landlord, I'm going to basically force the subcontractor to comply. And in the real world, quite often, the subcontractor might have a good attorney like Jerry Keogh, and they might push back. But in the real world, it depends on a tremendous amount of different factors. 5 years ago, things were much different in the world of real estate and construction than they are today. Everybody knows that has a little bit of knowledge. How much work is out there? Right now, there's a ton of work out there. You can have really good subcontractors saying, pushing back, and if the owner that I represent says, you know, we're not going to agree to that language that Mr. Keel wants to add, you take it or leave it, then a subcontractor is probably a good subcontractor is going to leave it because there's a ton of other work out there they can go and get. 5 years ago, I had a whole bunch of subcontractors I represent, and I would give them the exact admonition that Mr. Keel's given the audience today, and because they were so desperate for work, they would say, look, I got to feed my family, I got to keep my men working, you know, I'll just have to deal with that risk. And they would sign a very oppressive contract because they didn't have the work. So the conditions, so I'll take Jerry's question today. Today, if I'm the owner and I want a good subcontractor, I'll be a little more flexible. I will not tell them that if the subcontractor wants some flexibility in the contract, then, you know, that immediately knee-jerk reject them and go to the next subcontractor. Because everyone's very busy today. At least the very good subcontractors are very busy. So you want to play with it a little bit where you have the most protection without telling a good subcontractor that you need to bring the job in time, have the job done properly. You don't want to lose those type of subcontractors. So my answer is a bit of a dance, Jerry, but I would say it really depends on the situation. And in today's environment, I would be a little bit flexible as an owner.
Would you be as flexible to take let's not take the term of amelioration, let's take the term of where I'm obviating the term. I'm completely wiping out by saying, notwithstanding the foregoing, you know, it basically doesn't apply to me because I'm only going to accept that which I bid for, and I didn't bid for anything that's unforeseen. Would you try to water down in a negotiation process that term of obviation?
Oh, absolutely. From an owner's perspective, my job is to protect the owner as much as I can in every instance. And of course, the owner holds most of the cards, so you do have quite a bit of leverage. And there are still contractors out there that are going to be willing to step up to the plate. Maybe it might cost a few more dollars to pay the subcontractor. I'm okay with that part of it, but I'm not going to concede the language in my contract to you.
And I think that's a great way, I guess, for us to wrap up this presentation. This issue, this debate between, you know, because I represent a lot of subs and Gerard represents a lot of the GCs in our practice. This dispute has been going on since 1780 BC. Delays are going to come. Everybody wants to build a house. How many times have you gone out and you go to build a house and you can't get it done on time? You know, it's the nature of the beast. Who's going to pay for that cost? And since we've been arguing about this back and forth, and some of the arguments that Gerard and I will have in the office about the fairness of the courts and the code, since it's gone all the way back to the Bronze Age, I think the admonition we would give landowners is make sure you have a lawyer who's got their eye on the prize, because the courts are changing. And the effect of the unconscionability and equity is starting to wear a little thin, I think, on the judges. And I think their view, because some of these subs have walked away with horrific losses. But I think if I was anybody who's in the business of developing property, I'd make sure that our lawyers are sort of keeping their eye on the prize as to how this issue is going to be resolved.
Winds are changing. Keep your eyes on the winds. Thank you, NIOM. Thank you, Margie Russell.
Have a good evening.
Good night.